In Envirocare of Utah versus Nuclear Regulatory Commission, we'll see whether an agency could deny a party the opportunity to intervene in administrative proceedings based on administrative standing criteria. The Nuclear Regulatory Commission granted Envirocare of Utah the first license that allowed a facility to dispose of radioactive materials from off-site sources. At the time, other companies only had permits to dispose of radioactive materials that were produced on-site. In the late 1990s, the Commission granted applications from International Uranium Corporation and Quivira Mining Company to amend licenses that would allow the companies to dispose of radioactive materials from off-site sources. Envirocare requested a hearing at the Atomic Safety and Licensing Board to intervene and oppose the amended licenses. Envirocare argued that the amendments would allow International Uranium and Quivira to become general commercial facilities. Envirocare claimed that the Commission didn't require that International Uranium or Quivira meet the same regulatory standards that Envirocare had to meet when it was licensed. The different regulatory standards would put Envirocare at a competitive disadvantage. The licensing board rejected Envirocare's request for a hearing, as well as its request to intervene. The Commission affirmed the licensing board's holdings. In Quivira's case, the Commission found that Envirocare didn't satisfy the standing requirement in the Atomic Energy Act. Under the Act, the Commission must grant a party's request for a hearing if the party has an interest that may be affected by the proceeding. However, the Commission found that Envirocare's economic interest didn't fall within the zone of interests that gives a party the right to a hearing or the right to intervene. The Commission also agreed with the licensing board's decision in International Uranium's case. The Commission noted that judicial standing doctrines didn't control in administrative cases because a regulatory commission isn't an Article III court or a federal court with presidential-appointed judges. Therefore, the Commission isn't required to follow the standing law that comes from the case or controversy requirement. Envirocare petitioned the United States Court of Appeals for the District of Columbia Circuit for review.